Hi everyone, and welcome to today's webinar on Centrelink debt and how your clients can understand their rights. My name is Catherine Bowden. I'm the Communication and Community Legal Education Officer here at Legal Aid, and sitting with me is Bryony Walters. Bryony is a senior lawyer and she works in the civil justice team, so she'll be presenting today. And as you can see, Bryony is wearing some lovely purple for Wear It Purple today, and this is to support the LGBTIQ youth.
Thanks so much, Catherine. So we're talking about Centrelink debts today. An issue that comes up a lot is Centrelink debts in the practice. And so there's some issues which really I think people need to know ahead of time to avoid a debt. So, you know, by the time you end up giving somebody advice, it's a bit too late. So it's good to have a chat about how to avoid getting a debt in the first place. Yeah,
it's great to have you all linked in, and so hopefully Bryony can help a lot with that today. All right, I'm just going to let you know that it is recorded, so you'll be able to catch up on the webinar at a later date if you or your colleagues miss anything. It is for community legal education purposes only. And I'd just like to pay our respect to elders past, present and emerging, and the traditional owners of the land on which we meet today. Okay, just a few housekeeping slides before I pass over to Bryony. Technical help is available on 1800 136 402. You can find more information on our community workers and carers page on Legal Aid Queensland's webinar website about future webinars. If you'd like to go ahead and download the handout now or anytime during the webinar, you can see a handouts box in your toolbar with a PDF, and that's today's presentation slides. If you do have any questions, you're welcome to submit them anytime. We'll likely just wait and answer them all at the end. We've got quite a few that have come through from people who have already presented us with questions, so thanks for those as well. Some will be covered through the presentation, but we might just recap at the end as well. Okay, let's start off with a poll. So, as we normally are interested in, what area do you work in? Southeast Queensland, Far North Queensland, Regional Queensland, or outside of Queensland? And we've got quite a few of you coming in from outside of Queensland today, so Bryony will be able to let you know when the webinar is relevant or not relevant to outside of Queensland.
Yeah, I might just say from the outset that Social Security law Centrelink staff, it's federal, it's a Commonwealth area of law, so it applies in the same way no matter what state we're in. It might be like I might speak to some referrals which are Queensland specific, so maybe I'll try and just speak broadly about the kinds of services that people should link into.
Okay, great. Thanks for that, Bryony. So that'll be very helpful for everyone linked in today. And if you're interested, I'll share the results with you. You can see that half of you are from Southeast Queensland. We've still got a really great amount of people from Far North, Regional and outside of Queensland as well. So thanks to everyone for joining us today. All right, now I'd like to pass you over to Bryony. She'll go through the outline and slides with you.
Okay, so we're just going to go through a couple of things. I'll start by speaking to how to challenge a Centrelink decision. A topic that I'm really interested in is talking to people about how we can support people to avoid parenting payment debts when they're also on family tax benefit. There's some pitfalls there to look out for. I was going to touch on Centrelink debts and bankruptcy as well, and then we'll talk a little bit about the role that Legal Aid Queensland has in helping clients that are dealing with Centrelink matters.
Another poll to get you started. We're interested to know how often you help your clients with Centrelink debts. This will just help Bryony frame the webinar and get a bit of understanding about how often you will need this information. So we've got a lot of you from, I guess 50-50 from Hardly, and the rest are monthly, weekly. And a couple of you will help clients with Centrelink debt daily. So I'll close the results off for now and share the results if you're interested. So there is still a fair few of you who will need this information weekly, monthly and a couple daily as well. And for those who hardly help clients with Centrelink debt, hopefully this will give you a lot of information. So when it does come up, then you'll be fully prepared. Okay, disagreeing with a Centrelink decision.
So broadly, when Centrelink makes a decision that somebody doesn't like, most of the time, almost all of the time, there'll be a right to appeal that decision. There's a process of appeals that people can move through in relation to any particular decision. We begin by obtaining an internal review, a review from somebody who's still within Centrelink but is different and separate to the original decision maker. That's an authorised review officer. If we don't get the decision that we want from that internal review with the authorised review officer, then we escalate the appeal to the next level. We go outside of Centrelink and we're looking to get a review of that decision from initially the Administrative Appeals Tribunal, Social Services and Child Support Division. This jurisdiction used to be called the Social Security Appeals Tribunal, but it was amalgamated into the Administrative Appeals Tribunal a couple of years ago. And so now we know it as the Administrative Appeals Tribunal, Social Services and Child Support Division. So this is our first opportunity to get the decision looked at again by somebody who is outside of Centrelink. If we don't like the decision that they make at that tribunal, we have another level of review that we can go to. So we can escalate the appeal again to go to the Administrative Appeals Tribunal General Division. Before the amalgamation of the Social Security Appeals Tribunal and the Administrative Appeals Tribunal, we probably would have just called this tribunal the Administrative Appeals Tribunal. But these days we call it the Administrative Appeals Tribunal General Division. So we've got the original decision maker within Centrelink. They make a decision that we don't like. We go to the authorised review officer. Then we go to the Administrative Appeals Tribunal, Social Services and Child Support Division. Then we go to the Administrative Appeals Tribunal General Division. And then if we still don't like the decision, we do have the option of lodging with the federal court, but the federal court can only look at it for us if we are able to make an argument that the law was applied incorrectly, that the tribunal didn't understand or interpret or apply the law correctly. So if it's an argument about the facts, then we probably are not going to be able to take it to the federal court. I think in real terms, it's probably not going to be an option for a lot of clients to take it onto the federal court in most cases. So that's it. Time limits. So when you're appealing, there are time limits to access these appeals in real terms when we're looking to try and get back pay for payments. So it might be a bit different if I've claimed disability support pension and they say, no, and I disagree, I want to stick to some really strict time limits that apply to me. But here, where we're talking about debt decisions, the situation's a bit different. If we're looking to appeal a debt, a Centrelink debt has been raised, and we're unhappy with that decision to raise that debt, then there's actually no time limit for me to appeal that decision to an authorised review officer within Centrelink. If the authorised review officer gives me a decision that I don't like, there's still no time limit for me to appeal to the Administrative Appeals Tribunal, Social Services and Child Support Division either. Once I get a decision from that first part, that first review at the Administrative Appeals Tribunal, once that first decision at the tribunal has been made, I only have 28 days, 4 weeks to appeal further to the Administrative Appeals Tribunal General Division though. So basically all the way through the appeals process until I'm looking at lodging an appeal with the General Division of the Administrative Appeals Tribunal, there's no time limit that applies to me. But I've got 28 days to lodge with the Administrative Appeals Tribunal General Division. With the Federal Court, I've got 28 days to lodge as well after the General Division of the Administrative Appeals Tribunal makes a decision though. Probably the takeaway there is that if Centrelink made a decision to raise a debt against me, even if it was a very long time ago and I've never appealed it, I could still appeal it now. You can still appeal a Centrelink debt even if you've entirely paid it off.
Oh, great.
And then if your appeal was successful, you get paid back the money that you already repaid to them, you get a refund.
Right.
So even if it's been a long time that's passed since the debt was raised, if you're unhappy with it, you can still appeal it.
So, Bridie, you could wait 1 year, 2 years, 3 years.
10 years.
10 years. Okay, awesome.
50 years.
50 years. No time limit.
No time limit.
That's great.
So just appeal. So I really wanted to talk about, I talk to a lot of people who receive family tax benefit and they also receive parenting payment and they end up with parenting payment debts which relate to their income. So a really common thing to have happen is that somebody is saying to me, oh, well, I've been on family tax benefit for quite a while. and I've been getting parenting payment, and I've kept Centrelink up to date to do with my family tax benefit, and now they tell me that I've got a parenting payment debt, and I don't understand how that could be because I kept them up to date about my income. One of the things to be really careful about here is that family tax benefit and parenting payment are very different payment types. Parenting payment is paid under the Social Security Act, and family tax benefit is paid under the Family Assistance Act. The Social Security Act also has payments like New Start allowance and disability support pension and age pension, all of those income support payments. Family tax benefit comes from a different sort of history. I think it was originally dealt with by the tax office, and it ended up getting pushed across to Centrelink at a different time. So the nature of it is sort of different, though there are lots of similarities. One of the things to note here is that even the way that income is defined for the purpose of parenting payment is different to how income is defined for family tax benefit. The thing that trips people up, I think, is that your entitlement to family tax benefit is calculated annually, but your entitlement to parenting payment is calculated fortnightly. So for parenting payment or New Start allowance or youth allowance, or I study a whole range of payments, if people are earning, we're probably familiar with this idea that you move through a fortnight. I'll just say from the outset, parenting payment is paid fortnightly in arrears. So it's kind of like having a job. You know, you start your job on day one, and if you're being paid fortnightly, you work for the fortnight, and then you get paid for the fortnight that just happened. With parenting payment, because the income, it's income tested. If you're working, then you start on day one and you move through that fortnight, and then at the end of the fortnight, you should report your income for that fortnight that just happened, and then they calculate the payment that's payable to you for that past period and get paid it. And then you start fresh again.
Yep.
You move through another fortnight, you report your income at the end of the fortnight, they calculate your payment and it gets paid out to you. With family tax benefit, the way that family tax benefit used to be paid to everybody is you move through the period of entitlement. Instead of being a fortnight, it's a year. And you would wait until you got to the end of the financial year, you would do your tax return, and they would calculate your family tax benefit and pay it to you for that whole year that it happened. So it was paid annually in arrears instead of fortnightly in arrears, like parenting payment.
Okay.
I think it was when John Howard was in that a change was made so people could get their family tax benefit in advance fortnightly.
Okay.
And this is where it becomes confusing, because it's kind of like at the beginning of the financial year, I'm estimating what my income will be for the whole financial year, and I get paid fortnightly on that basis. The end of the financial year, I do my tax return, and Centrelink does a process called reconciliation. So they use my tax return to calculate my entitlement to family tax benefit for the whole financial year. And then they compare what I was paid during the financial year with what I was entitled to, and I could get a top up, or I could end up with a debt, or theoretically I could break even.
Right.
So one of the other things to note here is that parenting payment isn't reconciled in this way. So once I do my tax return, there's no process within Centrelink to look at my tax return and consider whether or not my parenting payment has been calculated correctly throughout the financial year. So if I end up with a debt, it could be for a number of financial years. And I think one of the difficulties is that when people are receiving family tax benefit, there might be an expectation that all of my payments are reconciled each year. Well, my family tax benefit was reconciled last year, and they said that I only owed $200. Why didn't they check my parenting payment at the same time? But it's not linked in the same way. The processes aren't the same for the two payments. So it would be incorrect for us to assume that just because our family tax benefit has been reconciled in any particular financial year also means that we don't have anything to worry about in terms of whether or not our parenting payment has been paid correctly.
So, Bryony, is there any way that people can check these details themselves?
One,
is it a matter of waiting to see if you get a debt in the mail?
I would really encourage being proactive about ensuring that you're meeting your reporting requirements for both payments. It can be quite difficult as well because of the specialist nature of the people that you talk to in Centrelink. So just because you talk to somebody about your family tax benefit and update your income estimate, let's say that it's a family where two people are out of work right now, mum and dad are out of work right now, and they're getting parenting payment, family tax benefit, New Start allowance, and then somebody gets a job, mum gets a job. And so mum calls through and updates the income estimate for the family tax benefit, but the person that she speaks to may not mention to her, I don't know if it would be correct to say that they probably won't mention to her, because I only talk to people who have a problem Centrelink, so excuse my sense of what happens in the real world. But it may not become apparent to her that she needs to report that income fortnightly for her parenting payment. So as well as updating your income estimate for family tax benefit, you also need to report your income every fortnight.
Okay.
So you've got reporting obligations in respect of family tax benefit and parenting payment. So updating your income estimate for your family tax benefit is only part of the equation. You also have an obligation to advise Centrelink of your income each fortnight to ensure that your parenting payment is calculated correctly. The same issue that I'm talking about here also applies in respect of New Start allowance debts. So there might be lots of people out there who are on family tax benefit as well as New Start because they have children that they're caring for. So parenting payment would be relevant where the children are under 6 or 8, and then the person will, after their children reach a certain age, they'll transition onto New Start or onto another payment. But almost all of the social security payments, like New Start, age pension, parenting payment, New Start, they're all income tested fortnightly.
So it doesn't matter how many different Centrelink payments you have, you need to make sure that you're updating Centrelink of any changes for each payment.
Yeah, I think that might be the takeaway, that family tax benefit, you know, if you had to choose one or the other, I'd probably say reporting fortnightly for your parenting payment or your New Start allowance, but not updating your family tax benefit. Income estimate would be the way to go rather than having it the other way around.
But best to report
both. You want to report both. You want to have an income estimate for your family tax benefit and be reporting fortnightly for another social security payment like parenting payment or New Start allowance in order to avoid a debt.
And if anyone's got questions on that, feel free to submit them. We'll get to that at the end as well. Okay, another poll. Here we go. So we've spoken a bit about this, so we'll just see what you think here. To be paid the parenting payment, you must report income received by you or your partner every fortnight, month, or year.
Maybe one of the things to say here is that when I'm on a Centrelink payment, like parenting payment or New Start or Austudy, if I'm not working when I first granted the payment, I'm not going to be on a reporting schedule. So I'm just going to be paid every fortnight regardless. If I start a job and I advise Centrelink for the purposes of my fortnightly payment, like parenting payment, that I'm working, then they're going to most likely, and they should put me onto a reporting requirement so that I have to report every fortnight before I can be paid. If there's an administrative error that results in me not being put onto that reporting schedule, then I'm just going to be paid every fortnight, not taking into account my income. So,
and then you could be hit with a debt at the end because you haven't been reporting
your
income. So it's always best to just report your income and any changes.
And to be clear, the raising of the debt itself is not so much to do with whether or not you've done what you were supposed to do, or you've done the right thing, or you're honest, or you're trying your best, or anything like that. The raising of the debt in the first instance is really Centrelink saying you were paid this much, but now that we know about your income, we know that you really should have been paid this much. So regardless,
it's very administrative.
Yeah.
Okay, so we can see that most of you have picked up on what we've been saying about reporting the parenting payment fortnightly. So I'll just share the results on the screen with you there. There we go. So pay the parenting payment fortnightly. The family tax benefit was
yearly. So with my family tax benefit, I need to get it in arrears in a lump sum at the end of the financial year after I do my tax return. If I'm getting my family tax benefit in advance, I need to give Centrelink a reasonable income estimate. I can update that as many times as I want during the financial year if my circumstances change. But when it comes to parenting payment, in order to be paid correctly at the correct rate, taking into account my income, I should really be reporting income every fortnight.
Yep. And you can do that over the phone as well. You don't always have
over the phone. You can do it on the app. You can do it online. There's a range of ways that you can report.
Yeah.
tend to think it's not a bad idea to take copies of your pay slips and post them into Centrelink as well, if you want to do every single thing that you can do.
Yeah.
So this is really just a lot of the stuff that we've spoken to. So the real trap is that updating your income estimate for your family tax benefit is not the same as reporting your income for parenting payment. It's two different things. The family tax benefit income estimate is for the whole year, but when you're reporting your income for parenting payment, you need to be doing that every fortnight. So to be paid family tax benefit correctly, you have to provide an income estimate at least once a year. You can update it as many times as you want during the year, but to be paid parenting payment correctly, you must report income received by you or your partner every fortnight. One of the traps, and I spoke to this a little bit earlier, was that your family tax benefit is reconciled and checked every year after you do the tax returns. But parenting payment, New Start allowance, Study Youth allowance, all of those other types of payments are not reconciled annually after you do a tax return. Family tax benefit is the only payment that gets reconciled every year. So sometimes I'll talk to people, they've been receiving family tax benefit correctly for 5 years, but then they'll have 5 years worth of parenting payment debt because they weren't reporting every fortnight during that time because they thought that their family tax benefit income estimate was enough.
Okay, but it's not. You've got to report your income.
So if a parenting payment debt is raised, you can ask for a decision maker to consider applying a debt waiver to waive all part of your debt. That part of the debt is essentially just gone. It's not recoverable. It's off the record now. So there are two waivers which are available to us under Social Security law. There's the administrative error waiver and the special circumstances waiver. So there can be some challenges in getting the administrative error waiver applied, which is one of the things that I want to speak to here. So I guess broadly, when we're looking at a Centrelink debt matter, the first question on appeal for an authorised review officer or a tribunal is, does the debt exist? So that's basically a pretty cut and dry sort of question about whether or not you were paid what you're actually entitled to. And if there's a difference, then we end up having to say, yeah, a debt exists. There might be a bit of a question about how much that debt should be. If there's, you know, like if somebody had to amend their tax return later, then maybe the information that Centrelink used to calculate the debt wasn't correct, just as a for instance. But setting those questions aside, if it is correct to say that the person was paid more than they were entitled to, then the only thing that we can do with that now is to look at whether or not the person meets the requirements of either of the debt waivers. So we're not going to get access to broad open-ended discretions which relate to fairness or justice or need or deservingness. We're really only going to be able to get these debts waived if the circumstances meet the requirements of one of these debt waivers.
Okay.
So the administrative error waiver, the way that it's set out in the legislation is such that Centrelink must waive a part or the whole of a debt where the debt arose 100% because of a Centrelink administrative error and payments were received in good faith. So good faith is, it has a sort of specific legal meaning. This idea relates to whether or not we're not going to have good faith if something happened that should have reasonably led us to suspect that we weren't being paid correctly. So if for my parenting payment, a letter gets sent out to me where they summarize what I've been paid in the fortnights before the letter comes out, and they also summarize the income that I've reported, and it shows that I've been reporting $0 income, and I don't look at that letter and go, oh, wait a second, I told them what my income is, why aren't they using that? Then I'm probably going to lose good faith. So effectively, letters that Centrelink sends out to clients will often have the effect of destroying their good faith. If the person has trouble receiving their mail, if they have trouble understanding their mail from Centrelink, if they read the letter but then they don't do anything about it, these things will tend to destroy our good faith and prevent us from getting debts waived on the basis of Centrelink administrative error. But whether or not you can get access to this waiver also depends on the attitude of your decision maker. So if you call up and you give an income estimate for your family tax benefit, that's not the same as reporting your income every fortnight. So a Centrelink decision maker or a tribunal decision maker might be inclined to say, well, the debt arose because you didn't report fortnightly and you had letters coming out to you that advised you of your obligation to do that. In real terms, of course, I understand that, you know, people have busy lives, people live with impairment, people have literacy issues, people don't necessarily want to read their Centrelink letters, and Centrelink letters can be really hard to understand. So in real terms, I get that honest, hardworking people don't necessarily, this stuff is complex too, but the structure of the law means that the starting position is that if the debt exists, we're probably going to have to pay it back unless we meet the requirements of one of these waivers.
Which seems a bit tricky to meet.
With the administrative error waiver, to me, it often feels like it's difficult to meet those standards. And people, I think because intuitively people are going, this debt doesn't feel like my fault. When they hear about the administrative error waiver, they go, well, if it's not my fault, it's probably Centrelink's fault, so that means I should probably be going for the administrative error waiver. And there's probably arguments to be made. There was an interesting case called Tomlinson where the tribunal found that the letters were just not good enough. And so they said that there was no issue with good faith for that person and that it was a sole Centrelink error that led to the debt coming up. But I've seen so many of, I wouldn't bank on a tribunal necessarily taking that approach. And, you know, obviously it's better to just avoid the debt in the first place if you can.
But you're welcome to apply for a waiver.
Yeah.
You just can't guarantee that your debt will be waived when you go through the process.
I think that's it. Yeah. More useful than the administrative error waiver might be the special circumstances waiver, in fact. So Centrelink might waive all or part of a debt if there are special circumstances other than just financial hardship on its own, special circumstances which make it desirable to waive the debt. And it also needs to be that the debt did not arise because you or another person knowingly made a false statement or knowingly failed to comply with Social Security law. So one of the interesting differences here is that this standard where you need to have not knowingly made a false statement, it's easier to meet that standard than it is to meet the good faith standard. So you'll lose, losing good faith is like falling off a log, you know, it's really easy. But with the special circumstances waiver, there tends to actually need to be like positive evidence that you said something you knew wasn't true or you knowingly failed to comply with the law in order for this waiver to not be available to you. So most of the time, really the task is just to show that there's special circumstances which make it desirable to waive the debt. I'll say that generally, like, special circumstances isn't defined in the legislation, and the tribunal has found in the past that, you know, being in financial hardship is part of it and definitely part of what might make it desirable to waive a debt. If you are ill or have impairments or somebody in your family is ill or has an impairment, if there's high medical costs or care costs, if you have care responsibilities for somebody with a disability or somebody who is older, and that especially if that affects your ability to engage in paid work, even if anything unusual or out of the ordinary has happened to you, if there are Centrelink errors which have contributed to the debt, then that can also be taken into account in the special circumstances argument. So most of the time it won't be just one thing, it'll be a bunch of these things together that amount to special circumstances together.
And Bridie, what if someone's already paid the debt off? Can they still apply for this?
Yeah, absolutely. Yeah. Even if you've repaid a debt, you can appeal and ask for the special circumstances waiver to be applied. And if a decision maker finds that it should be, either for the whole debt or part of the debt, then you can get a refund of amounts that you've already repaid, you know, assuming that you know, if you've repaid the whole debt and then they waive the whole debt, you'll get a refund of everything you repaid.
Provided
So the special circumstances waiver, you might have a big change in circumstances since the debt came up. And so you could ask for the special circumstances waiver to be applied so that you don't have to repay that debt as a consequence of those things changing.
And that could happen halfway through your debt, and you might apply to get the rest of the debt waived.
Yeah.
And that falls under the no time frame.
No time limits to start asking for an appeal from the authorised review officer or from the Administrative Appeals Tribunal, Social Services and Child Support Division.
So if you have clients who could benefit from this, then you're welcome to bring it to their attention and see if they'd like to go through the process.
And the other thing is that even if, you know, you might have had a debt raised 10 years ago and you might have done an appeal then and moved through and got to the Administrative Appeals Tribunal General Division and that debt's still there or part of that debt's still there. If since you went through that appeal process previously, your circumstances have changed, maybe you've acquired a disability, you can start again and ask for the special circumstances waiver to be applied, again, taking into account your new circumstances. And if Centrelink say no, you can start that appeals process again.
Again and again.
Yeah.
So there's no limit to how many times you can appeal.
Theoretically.
Yeah.
if what you're asking for is the special circumstances waiver. I'm not so certain that they would look at the administrative error waiver again. But if you've had a really big change in circumstances, then I think that's a really good reason for a decision maker to consider the special circumstances waiver again for you.
Yeah, and consider is the key word. There's no guarantees that going through this process will have your debt waived.
The other thing about the special circumstances waiver is it's really good to have evidence and letters of support when you're going to an authorised review officer or to one of these tribunals about the special circumstances waiver. So letters from a GP, letters from a social worker, letters from a psychologist or a counsellor, doing a financial statement showing what your financial circumstances are. That's really good. If you've got any kind of evidence that suggests that there was a Centrelink error, that can be good as well. Otherwise, you know, you could write a statement where you explain what happened so that it's clear to the tribunal how Centrelink failures contributed to the debt arising.
Okay, and so you can write a statement, or does it need to be a static?
Probably just write a statement because you're going, when you do your hearing at the Administrative Appeals Tribunal, they're going to swear you in anyway.
Right, of course. Yeah. Okay, so there you go. So pretty straightforward process for the special circumstances waiver then.
Yeah. I think the challenge for a lot of people is getting the evidence together, approaching people to get the evidence, being able to communicate what needs to be in the letter of support that you want back, that kind of stuff.
Yeah, but Bridie's here to help. So
yeah, I've got some templates that I can give to people to support them to get stuff back from like a doctor or a counsellor. Yeah.
Okay, so if anyone wants a copy of those templates, then you can email webinars@legalaid.qld.gov.au and we can get the templates out to you that way.
Cool.
Okay, shall we run a poll? All right. Just to make sure you're all staying with us today, we've got a quick poll. John has been discharged from bankruptcy. Is John now released from all debts provable in bankruptcy? Yes or no? And we're going to go into bankruptcy in a minute. So pretty even answers at this stage, really. Only half of you have voted, so we'll give it a few more seconds to get those in. It's not a trick question. We'll be covering this in a minute. Okay, I might close it off there. So most of you have said yes, but really it's pretty even responses. So Bridie will go into.
You might know that I'm not an expert about credit law or bankruptcy, but I know that when we declare bankruptcy and then we're discharged from it, we're released from a whole bunch of debts, but there's some certain types of debts that we might not be released from. But I don't know if the word provable, maybe provable is the word that we use to talk about all of the debts that we do get out of at the end of bankruptcy. Either way, I know about the Centrelink debt situation when it comes to bankruptcy, but not so much about other types of debts. So I wanted to raise this because it can get a bit confusing for people, I think. So regardless of when my Centrelink debt relates to, if I declare bankruptcy and I'm not yet discharged from bankruptcy, Centrelink can't and should not be recovering from me. So every now and then I do end up talking to somebody who is currently bankrupt. They've not yet been discharged from their bankruptcy, but Centrelink is still recovering a debt from them, say for instance out of their payment. And so the thing to do is to immediately provide Centrelink with some evidence about the fact that I'm currently bankrupt and I've not yet been discharged from my bankruptcy, and Centrelink should immediately cease recovery action and perhaps repay to you what they've recovered from you during the period of the bankruptcy. I'd definitely be asking for those amounts back. Once you're discharged from the bankruptcy, once the bankruptcy ends, you're released from all debts which are provable in your bankruptcy, and that includes your Centrelink debts, except for those Centrelink debts which were incurred by fraud. And this question, this idea of the debt being incurred by fraud, isn't directly relevant to whether or not I've been prosecuted. So Centrelink, at the end of my bankruptcy, Centrelink has to look at my debts, and then Centrelink has to make an administrative decision about whether Centrelink thinks my debt was incurred by fraud. So it might, look, when people, not everybody who has a Centrelink debt gets prosecuted for it. There's millions, probably like 2 million Centrelink debts are raised every year, but only about 1,500 people get prosecuted. So everybody has a Centrelink debt. Debt is endemic in the Centrelink space for a range of reasons, but that doesn't always mean that the person acted knowingly or even recklessly. But it's this, if there is evidence, if Centrelink thinks that there is evidence that I acted knowingly or recklessly in relation to my debt accruing, then they might refer me to the Office of the Director of Public Prosecutions. It's kind of like Centrelink making a complaint to police. And then police make a choice about whether or not they charge me. But we're not talking about police here. We're talking about the Director of Public Prosecutions. So if Centrelink think that the evidence suggests that when my debt was accruing, I was knowing what was happening, or that I was being reckless in relation to that debt accruing, I probably did know, or I should reasonably have known that I wasn't being paid correctly, then Centrelink might refer that matter to Office of Director of Public Prosecutions, and they make a decision about whether or not I get prosecuted. I may not be prosecuted. But if I am prosecuted, even if I plead guilty, even if I'm found guilty, that doesn't guarantee that Centrelink will or should find that my debt was incurred by fraud. And even if I'm not prosecuted, that doesn't prevent Centrelink from finding that the debt was incurred by fraud. It's like this totally separate question. It's like, even if I get charged in relation to my Centrelink debt, the language in the legislation, like the offence that's set out in the law, it doesn't use the word fraud most of the time. Fraud is, I think fraud is like this kind of ordinary idea we have of particular types of conduct. So anyway, it's kind of like, at the end of my bankruptcy, for Centrelink to make a decision that my debt was incurred by fraud, there probably needs to be quite strong evidence that I knew what I was doing. But in either case, if Centrelink makes a decision at the end of my bankruptcy that my debt was incurred by fraud, and as a result they can continue to recover it from me after my bankruptcy has ended, that's a decision I can appeal to the Authorised Review Officer, and then to the Administrative Appeals Tribunal, Social Services and Child Support Division, and then to the Administrative Appeals Tribunal, General Division if I need to.
So it seems like there's always opportunities to appeal.
Yeah.
Whether or not it's granted.
Yeah.
That's one thing, but
there's
an opportunity.
You can definitely get the question looked at again.
Yeah.
And as you do that, you're also getting written decisions about why stuff is happening, which I think for a lot of people adds a lot of value, because sometimes Centrelink's just making a decision and you don't have a really clear idea of why. So getting it in writing from somebody.
Understand their point of view a bit better.
Which can help you to check whether or not you're inclined to think that it's legally correct or that you agree with it. So if you think that the decision is not legally correct, once you know what the real reasons are, or there's something else about it that doesn't sit well with you, then you can send it to the next level of review and make an argument or get evidence or get advice, get help.
And again, Bryony and the team are here to with that.
So,
Okay, another poll. So Mandy has been discharged from bankruptcy. She now wants to appeal the decision to recommence recovery. Would this be good timing for Mandy to appeal to the authorised review officer? Yes or no? Run through the question again. Mandy has been discharged from bankruptcy and wants to appeal the decision to recommence recovery. Is this good timing for Mandy to appeal to the authorised review officer? Well, most answers are going in one clear direction, a few in the other way. So just give it another minute, get everyone's results through. This will just help Bridie understand your knowledge of the authorised review officer and appealing decisions as well for the next slides. Okay, let's close it off there. So most of you said yes, still a few in the no.
it might be worth saying as well that if somebody has gone through bankruptcy and then been discharged from it and Centrelink have made a decision to start recovering a debt from them again, you've got the option of, well, you have an opportunity to appeal the decision about recommencing recovery. But if you haven't done it already, you can also just appeal the debt because there's no time limit.
Yeah, that's right, no time limit. So yeah, you can appeal any time.
I mean, for lots of people, it might make sense to try appealing the debt to get rid of it before you are looking at declaring bankruptcy, but maybe there's a whole range of other reasons to be declaring bankruptcy anyway.
That's right. So yeah. Depends on the circumstance.
So I was saying before, I guess we'll just summarise some of those thoughts. Whether a debt counts as being incurred by fraud is separate to whether or not you were prosecuted. Those are two independent issues. Even whether or not you were found guilty of a criminal law offence relating to your debt arising, that's still a separate, there's overlap here, but they are separate questions, separate issues. So Centrelink makes an administrative decision after you're discharged from bankruptcy about whether or not they tend to think that your debt was incurred by fraud based on whatever evidence they have available to them at that time. They're using a civil law standard. So this, whether or not you're taken to court in relation, like to a magistrate's court by Centrelink in relation to your debt with a criminal offence, all of those issues are dealt with like a criminal law standard. So like, you know, beyond a reasonable doubt is what they're looking at. But here, Centrelink making this decision about whether or not your debt was incurred by fraud, that's a civil law question. So it's decided with a civil law standard. I guess what I'm saying here, even if that's a bit far out, is that they're just totally different issues, determined in different ways. So the standard is lower. The standard of proof for Centrelink is lower to find that your debt was incurred by fraud. But there's all of these cases that say it's really serious to say that somebody incurred their debt by fraud. So you need to have really clear evidence. So again, if Centrelink make a decision and say that they think that your debt was incurred by fraud and they start recovering it after you've been discharged from bankruptcy, then the thing to do is to appeal to an authorised review officer if you're unhappy with that decision.
Yeah.
So in terms of how legal aid can help, we conduct advice clinics at both levels of the Administrative Appeals Tribunal. So if Centrelink has made a decision, somebody doesn't like it, they go to the authorised review officer, they don't get the decision that they want, and then they take their appeal up to the Administrative Appeals Tribunal, Social Services and Child Support Division, or the General Division, then we've got advice clinics there that people can get advice from. We do as well have grants of aid for representation at the Administrative Appeals Tribunal General Division, but we're generally unable to represent people at the Social Services and Child Support Division. Though people can, there's a community legal centre called Basic Rights Queensland in Queensland that can support people with representation services if they meet that services casework guidelines when they're doing a hearing at the Social Services and Child Support Division. For community workers, for financial counsellors, social workers, and community workers, able to connect with lawyers at Legal Aid who do social security matters directly. And I think do we have the flyer for making contact?
We can send that around.
Okay. Yeah, we've got a flyer with contact details for me and a couple of my colleagues who have expertise in relation to social security issues. So if you're supporting a client who has a Centrelink issue and you're wanting to get some advice and know where to go next or what to do next, then you can get in contact with us directly about that.
Yep, and we'll send that around. You're all on the list for the handout as well. So, okay, great. So we've got 14 offices around the state. Here's a few of them. If you're nearby an office and want to go in to have a chat to anyone, you're welcome to. Otherwise, wait for the handout with Bernie's details and the rest of the team.
I'll be upfront, but me and the two other lawyers who do Centrelink issues are unfortunately only based in Brisbane. So when if you roll into the Cairns office, we won't be there.
No. And the handout will be only for yourselves, for community workers, not to be passed on to any clients with direct phone numbers. Okay, and if you have issues other than Centrelink debt, you're welcome to call us on our information hotlines. And any questions, and we do have quite a few questions that have come through. We also have a lot that were asked before the webinar started as well. So first question, Bryony, who pays for all of these levels of appeal?
The taxpayer, they're free. So you don't have to pay anything to get a review from the authorised review officer or from either of the tribunals. When you go to lodge in the federal court, there is a filing fee, but you can apply for a fee waiver. And so there's some requirements about getting the fee waived, which might relate to whether or not you've got a concession card. And I think there is also provision for you to do a financial statement showing what your financial position is, to ask the federal court to exercise the discretion to not require you to pay the filing fee.
Okay, great. Okay, we might ask one of these questions that came through before the webinar started, and some of them will just be to recap what Bryony's already talked about. But in what circumstances will Centrelink waive the debt? Can you appeal their decision, and if so, how? I think we've well and truly covered.
I might say that yes, you can appeal Centrelink decisions. You start by appealing to the authorised review officer and making the request for review. There's no really strict requirements for how to request for review under the Act. So you can do it verbally, you can do it over the phone, you can do it face to face, you can do it in writing. There is like an online form on Centrelink's website that I've sometimes used with clients to lodge a request for review. And also, we're talking about debt right now, so there's no time limit for you to appeal to an authorised review officer or to the next tribunal. But if you've got clients who have other Centrelink issues where they're looking to appeal, even making a relatively casual expression of dissatisfaction or questioning the correctness of a Centrelink decision should, at law, be understood to be a request for review. So if that happens within 13 weeks of an original decision, in relation to a payment where you're looking for back pay, that could count as lodging. So how can you appeal? You just ask for a review. You really just need to get the request logged, and then you can provide evidence and maybe a written submission if you want later. So if you've got letters of support, you can provide them later, because it does take a little while to get your decision back from the authorised review officer.
That first step is just notifying Centrelink that
you want it looked at again. Yeah. So you don't need to use any really special language. You can say, I want someone to look at it again. I want someone more senior to look at it again. I'm unhappy with this decision. I want a review. I want an appeal.
Okay. Okay, great. So you can call up or email, lodge it online.
Yeah, I guess it depends on the circumstances of the client, what's going to be easiest for them. I wouldn't necessarily recommend calling.
Okay. There might be a long queue and you may not get the right person to speak to.
Yeah. And so part of that question was, in what circumstances will Centrelink waive the debt? And it's, you need to meet the requirements of the administrative error waiver or the special circumstances waiver.
Okay.
Unless you're able to establish that the debt just doesn't exist. So for instance, if Centrelink say that I'm partnered to my housemate and I should have been paid at the partnered rate and I should have had their income taken into account and I wasn't entitled to anything, if I can establish that I'm not in fact partnered to my housemate, then that debt just doesn't exist. It goes away. So I don't need to get it waived because it just isn't there at all.
Okay, then there shouldn't be a debt. All right, so people who have some money in their bank account, but So I might rephrase this question a bit. If you've got too much money in your bank account to qualify for Centrelink, can you still prove hardship?
Okay, so I think the question here might be to do with if I've got money in my bank account. I don't know, maybe it's about do I need to show that I'm in hardship in order to get Centrelink? So I'll just say that money, it isn't strictly speaking correct to say that you have to prove hardship to get a Centrelink payment. I think in order to meet the requirements to get a payment, probably be in hardship if you didn't get granted. It's just sort of, you need to look at the eligibility criteria for each payment and the requirements to be payable for each payment. So if I've got cash at bank, then that's an asset. So if I had $600,000 in my bank account, I'm probably going to have assets in excess of the assets test, and I won't be able to be granted a payment. Can we go to full screen? I've got some information about the liquid asset waiting period, which I think is relevant here.
Is it one of these, Bryony?
Yeah, it's that one right there.
Okay.
Yeah. Can everybody see that now?
Yep, everyone should be able to see that.
Okay. So the liquid asset waiting period is a maximum of 13 weeks. If I'm a single person and I don't have any children and I've got more than $5,500 of cash in the bank, as a for instance, then I'm going to end up with a liquid asset waiting period. It may be 1 week at maximum. It's going to be 13 weeks, and that's just a period of time before I can get paid the payment I would otherwise be paid. So the idea is probably to make the claim early. As soon as you know that you're going to need a payment, just lodge a claim. You've got a right to lodge a claim. A Centrelink worker might, try to give you some advice about whether or not you're likely to be granted, but you've always got a right to claim, to lodge a claim, and then Centrelink have a duty to determine that claim, to assess it and give you a decision about it. And so it might be that they say, oh, well, yeah, you're going to be entitled to New Start allowance, but because you've got $6,000 in the bank, you're going to have a waiting period of 1 week, something like that.
Okay.
These limits change from time to time. It's also a different situation. For instance, if somebody has a redundancy payment, that gets assessed in a slightly different way. But if we've got cash at bank, we can, no matter what, make an application for a Centrelink payment, and Centrelink just has to determine it and give us an answer about it, and we might have a waiting period.
Okay.
Or we might have a reduced payment because of assets.
Okay, but you're always welcome to apply. And Bryony, is CentrePay still a service that Centrelink can provide to their clients? Do you know?
The answer is yes.
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 Okay. Great. Thank you. I'll just go through one more on this list. Can Centrelink debts become statute barred?
I've got this answer on my phone actually. It used to be that they could. So there's a bit of the Centrelink policy actually. I might just bring it up in front of us all because that'll be pretty easy. 6.7.3.08. Is everybody seeing that right now?
Yep, everyone should be able to see that.
So as of 1 January 2017, legal proceedings or any action to recover a social security debt can be commenced at any time. The former 6-year statute of limitations no longer applies. This was something that Parliament did. A debt that was deemed irrecoverable at law before 1 January 2017 can't be pursued, but Centrelink can still accept voluntary repayments of the debt. Even when a debt was deemed irrecoverable at law due to the former statute of limitations, the debt still exists and the debt can be waived where appropriate, but it may not be possible in those circumstances for them to recover from you. So if a debt's particularly old, if we've got a concern about the debt being particularly old, it's probably a good idea to get advice about whether or not it's recoverable or whether or not it should still exist, stuff like that.
Yep. Okay, great. Let's move to a couple of the new questions that have come through. Let's go back to our PowerPoint. All right. What about holiday loadings for people working in permanent part-time jobs and receiving some New Start allowance?
So the idea is to report, or when we're talking about parenting payment or New Start or payments along those lines, payments that are income support payments paid fortnightly to us that are not family tax benefit, we basically need to report everything that we get.
Okay.
So there's this very, very broad definition of income in the law. So it's basically anything that we would get. So if we have holiday loadings in addition to our usually hourly rate, we need to report the gross income before tax that we get. So this can be challenging, right, when we have to report income before we get a pay slip. When there's loadings, this can get really challenging. So I think the best thing, there's a couple of strategies that you can use to try and reduce your risk of getting a debt. So if you only have one job, asking Centrelink to align your reporting period with your pay period. So your pay slip will tell you that you're getting paid X number of dollars for work that you did between this date and this date. So you should ask Centrelink to line up your reporting period for your payment more or less with your pay slip. What this means is that I might have to call Centrelink or report my income and estimate my earnings before I've got an opportunity to review my pay slip. But if I get my pay slip a week later, I can amend my report with Centrelink to make sure I've been paid correctly. I might end up with little debts. I should say as well that if we want extra money, if we've overestimated our income and the income that we received was actually lower and we want to get extra rate back from Centrelink, we've probably only got 14 days to amend our report and get the extra back pay.
Okay, so that's not long. So I guess, yeah, try and get your pay slips and send it off to Centrelink.
Yeah, if you have issues with pay slips, you might need some employment law advice.
Yeah.
It's a challenging situation when people are working shift work or work that involves loading. There is obviously a practical challenge in reporting your income correctly.
Yeah.
So the best suggestion that I have is getting pay slips and amending your report and making it easy to figure out whether or not you've reported correctly by getting your reporting periods lined up with your pay periods, so you can just compare what did I report and what does the pay slip actually say.
Okay, thanks, Bryony. All right, we only have a couple minutes of the webinar left, but you're welcome to stick around for a little bit longer if you want to go through some of these questions.
There was a question here that I was pretty interested in where it said, how can someone get their partner or their ex-partner to lodge their tax return in a situation where the person has a Centrelink non-lodger family tax benefit debt? So I'll just explain that if I'm getting family tax benefit on the basis of an income estimate, if I don't do my tax returns within a reasonable amount of time, I think it's probably 1 year now after the end of the financial year, if I don't do the tax return, at some point, Centrelink is going to raise what is called a non-lodger debt. And it's a debt where they raise a debt against me for all of the family tax benefit that they paid to me. And it's not that I'm not entitled to any of it. It's sort of like an administrative action that I think is designed to make me go, oh, I should really lodge that tax return. So let's say, for instance, I give Centrelink an income estimate, I get family tax benefit during the financial year, I don't do my tax return for more than a year or whatever, and they raise a non-lodger debt against me. They're raising a debt for all of the family tax benefit they owe me during the financial year. It could be 10 grand. And I go, all right, so I might have somebody correctly advise me that the way to deal with this is to lodge my tax return. I lodge the tax return, Centrelink sets aside the non-lodger debt, and then they do that reconciliation process that we were talking about, so they compare what I was paid with what I should have been paid. Some parts of family tax benefit are only payable to me at the end of the financial year after I lodge my tax return, but I've only got a year to lodge the tax return to get those amounts paid to me. In either case, non-lodger debt is raised, I do my tax return, the non-lodger debt is set aside, and then they do a proper reconciliation. I might still have a little bit of debt there, or I might break even. The timing probably means that I won't get my supplements if I want to get my extra amounts of family tax benefit. I've got to do my tax return on time. But we do end up in a difficult position where somebody, if I'm partnered during a particular financial year, then my partner's income is relevant to my family tax benefit rate. So we can end up in a challenging situation where there's been a separation and that other person isn't doing their tax returns, or even if we're not separated and we've got a partner who won't do their tax returns.
That's tricky.
If we've separated, there is Centrelink policy that talks about, is that up on screen?
Just for us.
Okay. Okay, so here we've got a part of Centrelink's policy that talks about this reconciliation process where there's been a separation. I guess if somebody's got a partner that they're still with who won't lodge their tax returns, you probably need advice in relation to that. But where there's been a separation, depending on the timing of the separation, there's various things that we can get Centrelink to look at. So, for example, where this gets confusing because the income year, because they use this language that's difficult to understand about which you are talking about. But if we have a separation that occurs well after the year I got my family tax benefit, then I'll just read here. Generally, a non-lodger debt arises if income tax returns for me and or my partner are not lodged by the end of the lodgement year. The lodgement year is the 1 year period after I got my family. I get my family tax benefit in 2016, and then I've got all of 2017 to do my tax return, and then if I haven't, then a non-lodger debt will arise. So that's where they're recovering all of they're saying that they want to recover from me all of the family tax benefit they gave me. So generally the non-lodger debt arises if my tax return hasn't been done by the end of the next year. If the tax return for me and or my partner isn't lodged within that time, then like extra amounts of family tax benefit don't end up getting paid to me. If the separation occurs after the lodgement year, the year in which I'm supposed to lodge my tax return, any non-lodger debt raised against me will be written off if it's only my ex-partner's tax return that hasn't been lodged. This will result in suspension of any non-lodger debt recovery from the date of my separation. They can't do a reconciliation in the meantime, so they can't pay me top-ups and stuff like that. Once the tax return is done, then they'll do reconciliation properly. So I guess the takeaway here is that if separation has occurred and you've got an issue because an ex-partner won't do their tax return, then really the debt should be written off, like it shouldn't be recovered from you. So what I've found in the past sometimes is that Centrelink have not really connected the dots and applied that part of the policy. So we basically just put it to Centrelink that based on this part of the policy, they shouldn't be recovering that debt from that person because they're obviously not in control of whether or not their ex-partner does a tax return or not.
Okay, thanks, Bridie. And I think we've got time for just one more question. Someone had asked here, can Centrelink take money from your bank account direct if you have a debt without knowing about it?
Centrelink do have power to do that. Centrelink don't generally tend to do that. So most of the time when I've got a Centrelink debt, Centrelink will do, I guess Centrelink are looking for the simplest options in terms of recovery administratively and the lowest cost options to take to get debts recovered. So what I mostly see is Centrelink taking amounts out of people's payments, out of people's Centrelink payments, or recovering people's tax returns. There is capacity for Centrelink to garnish bank accounts, but I just don't usually see it happening. Okay. Theoretically they could, I don't usually see it happening.
Okay, thanks.
If that did happen or if that was going to happen, then somebody should get advice.
Yeah.
The other thing to say as well is that when Centrelink's recovering a debt, the rates that they generally tend to recover straight out of somebody's payment are quite high and are probably not affordable for most people. So what you want to do is negotiate with debt recovery unit to get it down to 20 or 15 a fortnight if that's something that's more reasonable for somebody. If somebody can't afford 15 or 20 a fortnight, then they probably want to request a write-off, a temporary suspension of recovery action. They might have to do a financial statement to show that it would cause them hardship, unreasonable hardship if they had to pay that 20 or 15 a fortnight.
Okay. All right, thank you. I think that's all we have time for. Do you have a couple of top takeaways for the audience before we leave them today?
I think probably the thing is that it pays to be proactive about this kind of stuff. If I would want people to walk away remembering anything, it's that just because you update your income estimate for family tax benefit doesn't mean that your income is being assessed correctly for your parenting payment. And if you have a job and you're on parenting payment on New Start in addition to family tax benefit, I would expect that the person should be reporting fortnightly, and if they're not, I would be quite concerned about whether or not they're being paid correctly.
Okay. Thank you, Bridie. And thanks to our audience for linking in today. There's a great amount of questions there that we haven't got to today. So if anyone would like to email webinars@legalaid.qld.gov.au, then I can pass them on to Bridie and she can try and get to those for you. And keep an eye out for the handout and the contact details for the unit as well. So thanks, everyone.
Thank you, everyone.
Thanks so much, Bridie, for the great presentation.
No worries. Thank you, guys.
Thank you.